Good morning. Welcome everyone to the first meeting of the Criminal Statutory Review Subcommittee. As you know, Speaker Lucas established the House Equitable Justice System and Law Enforcement Reform Committee in June, and our first full committee meeting was held July 28th. The committee represents a bipartisan, diverse group of lawmakers that have been tasked with bringing the entire House substantial reforms to improve our state's justice system and law enforcement policies. This subcommittee will address needed additions and deletions to the substantive criminal law in South Carolina. Okay, next on our list, Duffy Stone, solicitor from my part of the world, as well as the current chairman of the South Carolina Commission on Prosecution Coordination.
Hello, Mr. Chairman, and thank you for inviting me to speak today. It's good to see you guys again. It wasn't too long ago that I've already talked to you about a good bit of this. And so I want to clarify a couple of things, and I did some research after Representative Bernstein and I discussed it earlier. And when it came to, and listening actually to Mr. Zweigel, which actually, honestly, I think I agree with about 95% of everything he said. And the most important thing that he talked about was the constitutionality of hate crimes and the fact that you've got a case, Wisconsin versus Mitchell, that has already affirmed the constitutionality of that. But in that case, it says something that I think is important for us to understand when we talk about hate crimes, because it talks about the why. It talks about what the purpose of it is and why somebody should be punished when their actions correspond with their intent, and why that's more severe, or why it should be taken, treated more seriously than other offenses. And what that Supreme Court decision said was because, number one, it increases the likelihood of retaliatory crimes. Number two, it's something that is likely to establish emotional harm on the victim. And number three, which is probably the most important of all, that it incites community unrest, which is, I think, something that we've now seen throughout this country. So I think the why is well established. I think the fact that a number of other states already have this, I think that it's been held constitutional, is all important information. And the question really that we go forward with now is, how do we do that? If it's something that this body is intending to do, what is the best process? The constitutional concern is one that Representative Bernstein and I spoke about last time, which is Apprendi versus New Jersey. And the concern there is that if a sentencing judge is going to go beyond what the maximum penalty is for that particular offense, so if a penalty carries 0 to 10 years, but the judge wants to add in an additional penalty on top of that, and in Apprendi, actually, it was another 3 or 4 year sentence that the judge added. If they do that, the facts have to be shown to the jury. The jury has to be the one to find that. They have to find it beyond a reasonable doubt in order for the judge to go beyond that. Now, this has been something that's been discussed extensively throughout the country because it affects sentencing guidelines throughout many of these states. So this is certainly an important issue, but a number of states have come up with ways in order to establish a hate crime statute that allows the judge to do just that in a constitutional way. And if I could, the way that it appears to me is basically this can be done in 4 different ways. The first one, and I said earlier that Mr. Zweigel, I agreed with him in all but about 5% of what he said. 2 things. One is the Georgia statute was passed, I think, in June. Nobody has any idea how that works yet. We're not in court. We're not trying cases. They're not trying cases in Georgia. I spoke to Meg Heap, who's the district attorney in Chatham County, 15 minutes ago, and she said, you know, we haven't looked at it yet. How it works in Georgia, we just don't know yet, and whether that's a good one or whether that's a bad one. But I am concerned about this from the standpoint of the elements, because we have a crime on the books called domestic violence of a high and aggravated nature. It is basically the combination between assault and battery of a high and aggravated nature and domestic violence, which means as a prosecutor, if I charge that, I go to the jury and I have to prove all of the elements of assault, battery, the high and aggravated nature aspect of it, plus I need to prove that they cohabitated or they had a child in common. There was something that established the domestic element of that. Any of those elements, if I leave any of those elements out, then the case is either going to be thrown out by the judge or found not guilty by the jury. That's the statute that I'm concerned about. That's what I don't want to happen. I don't want a duplication of the domestic violence of high and aggravated nature statute, which is what we have in South Carolina. And in fact, I recall being up here some, gosh, probably 10 to 15 years ago, talking to legislators about that statute, and at that time discussing whether or not it would be something that we could routinely use, because that was going to be an additional element, and that was going to be an additional concern. So from the standpoint of combining hate with the actual substantive statute, I would ask you, please do not do that. That is where we get into the trouble with the additional element that we have to prove, or it throws out the entire underlying offense. I will tell you that the state of Oregon has that situation. I talked to the district attorney in a county up in Oregon very recently, and it's actually part of their elements that they have to prove. And so they charge it in the indictment along with the other charge, and if they don't prove it, the entire offense is done away with. However, there are three ways of doing it in which none of that's applicable. One is what you've already suggested, which is the instruction to the judge. Basically, special interrogatories that goes back to the jury from the judge that says, if you find this, then you may find this type thing. My experience with special interrogatories has not been much. I have not had that situation really since I practiced civil law. But I am concerned that the more jury instructions that go to the jury, the more confusing it gets. And quite frankly, it just doesn't seem as clear. Although I will tell you that the district attorney friends that I have in New York that do that, they said that it is not a problem. So it certainly is constitutional. It's certainly something that doesn't challenge the underlying offense. I will tell you, though, it is not, at least mine and a couple of other solicitors' preferred way of doing it, just because I think it becomes something that's more confusing for the jury. The second way to do it that is the same that we do in South Carolina 1623-490, which is the use of a firearm during the commission of a violent crime. That is a 5-year offense that is tacked on to, let's say you're committing a murder offense, you've got a murder indictment, that's a separate indictment, and then you've got a totally separate offense for use of a firearm during the commission of that murder. The jury can find guilty or not guilty on that indictment, but they can't find guilty unless they find the underlying murder. That is another way of doing it. It is a little bit cleaner, I think, but it is certainly another way to do it. And then that underlying offense carries a 5-year penalty. It is a mandatory minimum penalty. There's some exceptions if they're dealing with a life sentence and things like that. But that is already part of South Carolina's law, and that is another way of doing it. The third way of doing it, which is I think, and again, I'm speaking for me as a solicitor of the 14th Circuit, I'll tell you that I spoke to Solicitor Wilson in Charleston and Berkeley, who also agrees with me. I think Barry Barnette, solicitor from Spartanburg, Cherokee, is supposed to be here today, and he's going to talk to you. They currently do that with the graduated penalties in DUI cases. So he is very familiar with the use of a bifurcated proceeding in which you try the case. If the jury comes back guilty, then you go back to the jury with any additional evidence, argument that you may have, and it may not be much. From the people that have done this on a regular basis, and I will tell you that the state of Virginia, all of their cases are bifurcated. All of the cases in Arizona are bifurcated. I thought that was a kind of an interesting thing, and they actually like that procedure as well. I think we also need to take into consideration that a motion for bifurcation can be made by the defense at any time anyway. If you've got it, even if I think under special jury instructions, I think certainly the defense would have a right to make that motion. I would rather have it structured, just so that we all know what we're doing going in and not have that argument. The way we do the death penalty is obviously convoluted. It's something that obviously takes, and the last death penalty case tried took about 3 weeks to try. But I don't think it has to be that way. I think that any type of, I think a bifurcation can be a simple proceeding, and it certainly sounds like it works very well in the state of Virginia. It works, interestingly, in Oregon, they actually bifurcate everything except the hate crimes statute. I don't know why that is. I can't answer that. Bottom line is this, though. I think that what you are trying to do is important. I think that there is a reason to have a hate crime bill. I think that, interestingly enough, if you think of murder or homicide in the state of South Carolina, people are charged with murder, voluntary manslaughter, or involuntary manslaughter, and the difference is their intent. The difference is their underlying motive. If it's malice, it is murder. If it is in the heat of passion, it's voluntary manslaughter. And if it's a reckless disregard for the safety of others, it is involuntary manslaughter. But even aside from that, every day in every court in South Carolina, judges, we charge for actions. As a prosecutor, I prosecute people for committing crimes, actions. However, when it comes to sentencing, their motive and their intent and what's in their heart is always relevant. And it's always something that goes before the judge when it comes to sentencing. So it's not particularly a novel approach to take into consideration what's in somebody's heart when they commit a crime. And I think that it is proper. It is constitutional, with the only caveat that it has to be proven to the jury if you're going to have an enhanced sentence. And I would submit to you, if you're not going to have an enhanced sentence, you're not actually going to accomplish much. Otherwise, we already have all of that in place. So I applaud what you're doing. I recognize that the bills that were introduced last year, I think are constitutional. I think they work. I don't think they challenge the underlying offense. I would just suggest to you that you do take a look at an opportunity to set it up as a bifurcated hearing to see if that's something that we could all work on and make work. I'm willing to work with you on any of that. The only one that I would strongly ask you not to do is basically the same thing that we have in domestic violence of a high and aggravated nature. So thank you so much for having me. I appreciate it, and I'll be glad to answer any questions that you have.
Questions by members of the committee? Representative Bernstein.
Thank you so much, Solicitor Stone. I appreciate your comments, and I'm glad that we straightened out some of the constitutional issues that you and I had discussed. And I wanted to talk to you a little bit about the bifurcated process, because as I indicated at our last meeting, I don't practice criminal law. So it's my understanding that process is typically utilized in the death penalty.
That's right.
What other scenario besides the example you used in Spartanburg with the DUI case?
I think your DUIs are having to do, in any of the, if you have an increased penalty based on, for instance, the reading of the breathalyzer, then that's, and I do want Solicitor Barnette to have an opportunity to talk about that, because he does that on a regular basis. He says it's actually rare because in most cases I think he deals with refusals, but when it comes to the penalty enhancement that goes along with the reading of the breathalyzer, then they're bifurcating that. Solicitor Wilson told me many times about the bifurcating that they used in federal court when it came to, I believe, drug cases, which is that you prove the possession and then the amount is a separate hearing. In both of those scenarios, though, the description that I'm receiving from this, and quite frankly, it's also from the people in Virginia and Arizona, it's basically the jury comes back, we find the defendant guilty, the judge says, if you will hold on just a moment, there may be additional evidence that is presented, and then the state and the defense are allowed to present additional evidence. That may come in the form of an argument, it may come in the form of, it's got to come in admissible evidence, but it can be evidence that was already in that you simply stand up now and say, here's your argument. So I have not heard any horror stories about this is the worst thing ever when it comes to that. And it just seems to me that it is clear. The other end of it is, too, the defense can make a motion for a bifurcated hearing as it is. So I don't know that if we set it up that it is just the judge sending in special interrogatories, that precludes the defense from making that bifurcated motion anyway. And if that's the case, again, I would like it legislated so we know exactly, everybody knows exactly what they're doing going in.
So I guess that I'm trying to figure out, are you using a bifurcated process for sentencing besides death penalty, you personally?
No, I have not.
Okay.
I have not.
And so the only reason I have an issue maybe with the bifurcated process is, former Solicitor Pope mentioned at that full committee meeting that if you have your conviction, you might not, as the prosecutor, go that additional step. And we want to make sure that the impact of this hate crime bill is substantial. So, in looking at the bill that Representative Gilliard and Weston and I had sponsored, and Hyde, I'm not sure if you're on that, Max, if you're on that, but we have in that legislation, I'm not saying this is ideal language, and I think it's something that this committee will look at, but we do have language in here about a special verdict form. And in doing some research, I was talking with one of the attorneys with ADL who practices, he's a lawyer who's in Florida, and he sent me a jury charge. And what it says is, okay, you found this defendant guilty of this underlying crime. Now determine if it was based upon some perception of the victim's faith, religion, sexual orientation, whatever it may be, that bias class. And it goes through that description of the different aspects. And so you've already made that case for it. And then you're asking the jury beyond a reasonable doubt, because we do need to make sure, because I think that was one of the issues with the Prende maybe. With that standard. That to me seems a more efficient, streamlined process and doesn't create an additional step necessarily for the prosecutor. Because I understand your concern that you don't want to lose the conviction itself. I think that's what we had talked about, and I think you're comfortable that that's not going to happen. And also, Mr. Zweigel's testimony, he also talked about how prosecutors could probably present certain evidence if you're trying to get into this the criminal defendant was a member of some group, that you might not be able to get that into evidence on the underlying crime. But if you're trying to establish motive and hate, then you might be able to do that, which I would think would be advantageous for you in that role. So I'm just, the bifurcation to me seems like it's an added step that probably isn't as efficient as maybe doing a special verdict form, which we have prescribed in the bill.
No, it's interesting. I tried a case a couple of years ago that started out as a 3-defendant case that we ended up having to break up into 3 separate trials. And we actually had a debate, just as a friendly debate, with the court to determine which one was actually more efficient. If we'd have tried all 3 defendants in the same court, but it had lasted 3 times longer, or we broke it into 3 smaller trials. I will tell you that the efficiency is something that I'm always concerned about, but never to the extent of running a risk of confusing the jury. When you're a prosecutor, you're in a little bit different position, and I did some criminal defense work, so I've got a pretty good idea on how if as a criminal defense attorney, if I could confuse the jury, I'm doing pretty well. If I'm a prosecutor, the last thing I want is the jury confused. I want it clear. I want them to understand exactly what it is. In any scenario, I don't put in evidence in my case that's not directly relevant to the point itself, because I don't want to confuse the jury. I don't want them back there scratching their head going, I'm not sure about something. I don't really know what it is I'm not sure about, but I'm not sure about something. So I must have a doubt in which, a reasonable doubt. That's my only concern with it. Can it work? Absolutely. It works when we use the standalone statute for use of a firearm during the commission of violent crime. And quite frankly, that's probably, if I had to rank them, I would rank that second. Because I think at least, again, it's very clear, guilty or not guilty, and what goes into the jury in that would be an instruction that if you find them not guilty of the manslaughter, you can't turn around and find them guilty of the possession of a firearm during the commission of a violent crime. So that's instruction is working, and that works pretty well. My concern is just making sure that it is a clear, clean process, and that it's constitutional, and that it's fair. And it seems to me that, again, I think all 3 of those work. The only one for me that will absolutely not work would be the combined element into the underlying offense.
Other questions? Solicitor, thank you for being here. A quick question. I mean, based on what you just said about the add-on statute relative to the gun being used.
Right.
Your proof is the same, even if we were going to use a special verdict form, right? I mean,
That's correct.
Essentially.
That's correct.
So the only difference would be whether there was a separate crime to be charged in the indictment or an enhanced penalty.
Yep.
To be presented and proven to, or attempted to be proved to the jury, and a special verdict form. Doing
correct.
virtually the same thing. If you find guilty, then do you find that it was biased and motivated by in the special verdict form?
That's correct. That's correct, Mr. Chairman. And it works well. It does. I think my concern is this, and I want to make sure that I'm covering this. Again, I'm supportive of this. We can make this work. I will work with you on any of these that you want to do. I think my concern is this. When we charge possession of a firearm during the commission of a violent crime, that's not a hard element to prove. If you prove, if you're, that kind of goes in, if somebody comes in and beats you over the head and holds a gun in your face, it's really not hard to prove that they had a gun and they committed the crime. That's very rarely that you have to really argue that too much. Even in domestic violence of a high and aggravated nature, that element is sometimes tricky, but not often. I mean, you still have domestic violence. Did they live together? They have a child in common? This is something that's pretty concrete that you can prove. When it comes to hate, when it comes to the underlying motivation behind somebody, that I believe is going to be, I think it's appropriate. Again, I like the idea, but it is going to be more difficult than the standard elements that we're dealing with, because now you're having to prove why somebody did something. And that's 9 times out of 10, when you're prosecuting a murder case, that's the argument that you have is, was it really malicious, or was there some other reason that they did it, and that type of thing. So that's why it is a little bit different for me, but it will work in any of those circumstances. And again, I'll be glad to work with any of you to make sure that we get and cover all the constitutional basis, but it can work in any one of those 3 ways.
Okay. I guess my thoughts and concern, one, efficiency, as Representative Bernstein spoke to, but also the very concern that you just shared about the difficulty in proving that weighs against the notion that it may be actually utilized, because if you've gotten the conviction, right, underlying conviction, there may be an effort to say, this is too difficult, it's going to take too much time, we're not going to proceed with this bifurcated process for the add-on. And then the entire motivation for having a hate crime, to protect society, to have it discussed in the main case, to have it discussed as a possibility, we've lost it. And we've lost perhaps the deterrent effect. I mean, those are just my thoughts as we're interacting. So it seems to me that the notion of a special verdict form does allow you as a solicitor in your main case, not as a required element, but to have that charge being discussed, have the proof being discussed in the courtroom and in the media and in society, as including the tool that was given to you all to protect not only the individual victims, but also the community at large, which is what we're talking about when we start talking about the impacts to business and social justice and the greater community, rather than just the individual victims that may be at issue. Last question, you commented the defense can make a motion at any time for a bifurcated hearing, and that obviously death penalties are the only ones that you actually do. How often does that happen?
Not very often. Now, but we're also not dealing with again, if you're dealing with possession of a firearm during the commission of a violent crime, nobody's good. That's right. That's easy. And you're absolutely right about whether or not we use it or not. That's my main concern. My concern when I talked to legislature many years ago about the domestic violence is I want to be able to use this. I want it to be a benefit. And I will tell you that I agonize over what charges to bring against defendants in every case that I try. I need to make sure that the ones, and I have actually had death penalty cases in which I have not brought crimes that I'm pretty confident the defendant committed, but because it would confuse the jury. So I will tell you that when it comes to me, in my analysis of whether or not I'll use it or not, number one, without any doubt, will be, is that going to help the jury understand what's going on, or is it going to confuse them? And if it runs the risk of confusing it, I won't use it. If it does, and it takes me another day, that doesn't slow me down any. And I really don't think that it'll slow many of the other prosecutors down as well. So, I mean, just from that standpoint, my motivation is the same as yours on this. I want to make sure that we actually have something that we can use that actually benefits us. So not having an additional penalty to it would not benefit us. We'd never use it. Having it tied in with an element that we've got to prove that would risk the underlying offense, it is going to make it an unusable statute. And the other concern I've got is making sure that it is not something that would confuse it. And there may be a way of doing that in all three of those scenarios.
Okay, I hope so.
Yes, sir. Yes, sir.
Statistics are a wonderful thing.
Right.
They're also a bad thing, and in some respects, and present company excluded, of course. Things that are more difficult, sometimes folks don't go down that path because they're concerned about the statistics. And of quite frankly, conviction rates. Right. And what we want to make sure that in doing this and passing hate crimes legislation, that we've given you a substantive tool that's not just on the shelf to be possibly done in the easiest case to prove, but that one that gets talked about for its greater societal impact outside the courtroom. At least in my discussions with colleagues, that's in large part a motivation.
And I agree with that, and agree with that, and be more than happy to work with you in any way that we can to make sure that that works for everyone.
Thank you very much. Did you have another question?
Can get this later, but was it statute 1623-90? Is that what you said?
490, 16-23-490.
490, okay.
The additional punishment for possession of a firearm during the commission of, or attempt to commit, in that case, a violent crime.
Okay, thank you.
Any other questions?
Yes. Other than what you just stated and brought forth, you didn't have any other problems with either the hate crime bills?
Absolutely
that we
not,
addressed,
no, sir.
right?
In fact, I like it.
Okay.
I like the idea, and
Yeah.
I think it's something that we need to do.
Okay, thank you.
Yes, sir.
I guess one last question. You put in a suggested bill as well?
I took
early on.
took what the three of you actually introduced last year and just added the bifurcated procedure in it. I think the intent was to use your exactly how you wrote it last year.
Got it.
With the only difference being that, and when you do that, you have to send notice to the defense, which is also the provision, because otherwise you're not really giving them, if you give them an indictment, they get notice. If you're not doing it on an indictment, you need to be able to provide them notice. So that's written in there as well. And I think there's also a provision in there that the evidence in the primary case before it goes to sentencing is also admissible in both of those areas. So it doesn't affect that from the standpoint of losing evidence that you're not able to show in a normal case. But yes, it's identical as far as it's just a procedure. And by the way, if any of that I've left out, then I'll be glad to sit down and put it back in there.
And Solicitor, thank you. You know, as I understand our charge from both the Speaker and from the Chairman Rutherford and Chairman Simrel for our subcommittee, is, you know, we're in the second of a 2-year legislative cycle. Any and all bills that have been previously filed will time out.
Right.
And that our charge is to come back with a recommendation for a model, if you will, or a form of a hate crimes bill recommended to the full committee for then its review and deliberation and approval and recommendation as legislation to be pre-filed coming into January. So any of the bills that have been filed in the past, while they're elements and components of what we may be discussing today and how those may be changed or shaped, you know, what we're talking about doing as the group of 16 that the Speaker appointed is coming up with products, not just in this arena, but as it relates to the other components that he identified as well, legislation to be pre-filed when we're going in January. So thank you again for your time.
Thank you, Mr. Chairman. Thank you, sir.
Okay, the next is Barry Barnette. Good afternoon, sir. We appreciate you joining us today.
Hey, Mr. Chairman, thank you. Thank you, Mr. Chairman, members of the committee. Can you hear me, sir?
Yes, sir, we can hear you. Thank you for being with us.
No problem. I just want to follow up with Solicitor Stone, what he was talking about. I'm sorry about the echo we're having. One thing I wanted to point out is the bifurcated trial, I think, is the way to go. And there's several reasons for that. State v. James Cross case, where the South Carolina Supreme Court has done a bifurcated trial. Bifurcated trial situation from there. And what happens is, that was a involvement of sex offender registry case. He committed a CSC crime, and our Supreme Court has decided a bifurcated trial is a way to handle any kind of prejudice involved with that. And the problem is, if you do, like example, some of the evidence we can use in the trial, let's say it's an attempted murder case, is an underlying offense. And then we have the hate crime with it also. You can try and add some evidence is going to be allowed for the attempted murder, obviously show motive, things like that, but there's some evidence may be too prejudicial. So the one thing I want to do is make sure we keep the conviction for the underlying charge as well as the hate crime. And I think when you bifurcate it, it avoids that issue. And like I said, we've had to deal with it in Spartanburg, and actually in sex cases that we've tried, we've had a bifurcated trial. And it can be very simple. You can have most of your evidence presented during the major trial. You have a verdict of guilty. The judge charges them, well, ladies and gentlemen, they're considered another charge, the hate crime. They'll read the statute, and then go through the evidence they need to go through. It can be very simple. It could be an argument. It could be an additional witness. Because a lot of the evidence is going to be presented in the major trial. And like on DUI cases, what we've done here is down in Master Court, when we do have a reading. And one thing I don't want to see happen, I don't want a hate crime that's so complicated. As the DUI law, I could talk to you for weeks about how complicated it is. I'm not going to do that. But I would like to have a law that is precise, to the point, and avoids any being overturned later by the Supreme Court because we have issues on it. I understand the special interrogatory form, and like I said, that would be a simpler method, but I'm afraid it may open us up to situations where it could be overturned later. Especially if there's evidence that we want to use to show the hate crime that they may feel like it's too prejudicial for the underlying crime. Like in the Cross case, you have a sex offender that committed a CSC crime, and it's an element that basically we're going to segregate that so prejudicial. And with the hate crime, I think you want to introduce everything you can concerning it to prove it. And obviously, when we charge something like that, we want to follow through with it, just like the CSC case. And I just want to point that out to the committee. From there, Solicitor Stone's talked when we change the same concerns. In the world today, what we're dealing with, we need to have additional laws to handle things like this. And I can tell you one thing, this solicitor will follow through with it. But I could keep going on. If you need additional information or if you have any questions, I'll be glad to take those.
Thank you, Solicitor Barnette. Questions by members of the committee? Yes, sir, Representative Hyde.
Thank you, Mr. Chairman. I just would like to thank my friend, Solicitor Barnette, for taking time out of his hectic schedule. He's a real lawyer. He tries cases all the time, and he speaks with expertise and professionalism when it comes to trial procedure and how to get results. So we listen carefully to you, Solicitor Barnette. Thank you.
Representative Hyde, thank you.
Other questions?
Any?
Tell me, what was the case you mentioned? You faded in and out. You mentioned a case that was recently before the Supreme Court.
Yes, sir. State versus James Cross. Yes, sir. And I can give you the site if you want it.
That'd be great.
832 Southeast 2nd, 281. And it's a 2019 case. And we've actually going to use that procedure up here. We actually, when we try CSCs, we're dealing with that issue.
And speak to that case again for me, if you will. I lost you when you first talked about that case.
I apologize. Sharon, what it was, basically, the court, I think it was a Greenwood case. Basically, in the past, we've introduced, when somebody's a sex offender and they commit a CSC crime, that we can introduce it as part of the element so the jury knew about it. And we consider that as part of the CSC charge, you know, from there. But what the court did was they basically said you can't do it. It's too prejudicial for the jury to know he is a sex offender register, already registered for a previous offense. So they ordered that we have to bifurcate the trial. We actually try the CSC first. Usually it's involving a minor with a child. Once we get conviction there, then they consider the additional penalty, or they can consider the additional facts with the sex offender. And it's very simple. You just show that they're a sex offender. You show that they've been registered as a sex offender from a previous offense.
Okay.
And it's very straightforward. I think it would eliminate the prejudice that you may have, because I know the public defender spoke earlier, they're going to fight to try to keep everything they can out about the hate crime in the line of offense. I mean, we're going to want to introduce it. But this way, it avoids that issue of prejudice, because some of it will go towards motive, things like that. A lot of it will be shown in the majority of the case. But there are some things that we may not be able to show, or they may be too prejudicial, that we can use the hate crime to show. And of course, we'll be asked to go forward on that and ask for additional penalties to go forward on that second part of the trial.
Yes, sir.
Once they come back. But I just want to make sure you're aware of that. There is procedure. We're dealing with it. It used to just be death penalties, but it's starting to go into other cases. And on DUI cases, let me just use that for an example. There's 3 levels of offenses for DUIs. You've got the .08 to .10, you got .10 to .16, and above .16. There's different penalties for each one. What we've asked here is we've asked the judge to consider, you know, just let them consider the DUI offense. And a lot of times there's a data master reading that's introduced in the main trial. So the jury just determines that they're guilty of DUI or DUAC or whatever. Then they're brought back in, they give the verdict, and they say, well, we need you to do one more part. We need you to look at, if you agree, like it was .18. If it's .18, they agree that. But if they're given the range, it could be .10 to .16, .08 to .10. They can't agree, that goes to the lowest level automatically. So they did that to try to avoid juries talking about what they need to talk about, look in that line of defense, and then take because it's an enhancement, obviously. If it's .18, it's the highest level, so you pay the highest penalty. And then there's a mandatory minimum up to the maximum, and the judge will determine that. So from there, but I just want to make sure that the committee knew that it's already been done here in South Carolina.
Solicitor, thank you very much. We appreciate your time. We appreciate your input. And we appreciate your willingness to work with us along with Solicitor Stone and others as we try to move forward with a hate crimes bill that we can get past the General Assembly in our next session. So thank you again for your time.